Because it's an excerpt, it's titled Tactics and Strategies number 3, although the video immediately refers to this being the second video in the longer series. This video presents about 5 points to help deposing lawyers be more effective in taking expert depositions. This is the second of 3 video presentations covering the subject of taking effective expert depositions. In this video, I will briefly cover 8 tactics and strategies during the expert deposition to maximize your effectiveness while not weakening your position in the litigation. 1. Immediately before the deposition, recognize that you have a fairly narrow window to gain a psychological advantage over the experienced expert witness. Unfortunately, many lawyers miss this strategic opportunity, and I think this is a critical point. Depending on the experience of the expert, I usually suggest being very brief with the typical admonitions at the beginning of the deposition. Why? An experienced expert has been through these admonitions scores of times, and there is little value to wasting initial deposition time on them. In the 300 trials I've testified in, I have never been read an admonition from my deposition, leading me to conclude that they are of no value in an experienced expert's deposition. Spending time on them simply allows the expert to relax in the deposition room and size up the deposing attorney, while not facing any pressure of difficult questioning. If the expert has significant deposition experience, you should simply establish that fact and establish that the expert is thoroughly familiar with the deposition procedure. You should then directly proceed into the substance of the expert's analysis, which is where I think you should begin. Number 2, let me also mention the typical inquiry into the expert's background, education, and experience. If this inquiry is even necessary, it shouldn't be made at the beginning of the deposition. Why? It's a mindless exercise for the expert, and you are wasting valuable early deposition time in this area. Second, if you, the opposing counsel, anticipate that the deposition might be used at trial in lieu of live testimony, why should you qualify the opposing expert witness? Use the initial deposition time to immediately put the expert on the hot seat to list the expert opinions that he or she will be giving in the deposition. Of course, if there is a concern about the expert's true qualifications to render the opinions in question, the background, education, and experience needs to be examined. But again, is it necessary to do this at the beginning of the deposition? Think about this at least. Number 3, turning to your attitude and demeanor in the deposition. I certainly understand the benefits of using a more aggressive demeanor in a deposition depending on many different factors. A less experienced witness may be somewhat intimidated by an aggressive approach, and there may be a benefit to that approach in that situation. But with an experienced expert, a cool, calm, and collected approach is probably more effective. The chance is that the nice guy will get more information than the obnoxious antagonist. That's my experience anyway. I'm human. If a person is professional to me, I'll respond the same way. If the deposing attorney is obnoxious, I'll shut down, and he or she will get much less information from me. There's no absolute rule here, just strategies for lawyers to consider. Number 4, administratively. Near the outset of the deposition, but not right at the beginning, because I think you should ask for opinions first, you should cover the following areas. Review the deposition subpoena with the witness and ask the witness to confirm that he or she has brought everything that was requested to the deposition. If he didn't bring something, why not? Was he told not to? Was he just ignoring the subpoena? Put a little gentle pressure on the witness. Ask the witness to describe everything in the file. I think this is a great question. Why? You sit back and do nothing while the expert works. You might be surprised to find some important document buried in the file, or find out that the expert doesn't even know what's in the file. Next point, ask the expert what documents were requested for the case, what documents were provided, and what requested documents were omitted. and ask the expert if anything was removed from the file. And was he asked to remove anything from the file? This is a fertile area of inquiry. Inquire about billing to date. How much time has the expert spent on this case? How much time has been spent by the expert's employees? It's sometimes interesting to learn that the expert has spent about 5 or 10% of the total time on the case, and junior staff people have done the bulk of the work. Now I want to encourage you to go to Tactics and Strategies number 4 for a continuation of the points that were first raised in this short video clip.
Brian Peter Brinig is an adjunct professor at the University of San Diego School of Law and managing director of the forensic consulting group of CBIZ, a national financial services firm. The strategies and tactics presented in this video presentation are discussed in complete detail in his treatise, Mastering the Art of Expert Witness Testimony, which is available by scanning the QR code on the screen or on Amazon.